Good morning.
Good
Morning.
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 And yep, we have Mr. Devine here, so I think we're good to get started. Good morning, everyone. Today is Thursday, November 14th. The time is 9:32 a.m. And this is status conference, the matter of Robert Devine for the Massachusetts Peace Officer Standards and Training Commission. We are convening remotely via Zoom, and this status conference is open to the public and is being recorded. The Honorable Kenneth J. Fishman will be the presiding officer over today's status conference. My name is Lizzie Smith, and I'm the hearings administrator for the Post Commission, and this matter is now before Judge Fishman.
All right, thank you, Lizzie. Good morning, everybody.
Morning.
So I guess, Mr. Martinez, since we last heard from you about, and that's why we changed the order a little bit. Have you had any progress with regard to the U.S. Attorney's Office?
No, Your Honor, no luck with any response. I believe that we reached out 3 times and received no response, sort of as expected, but no confirmation one way or the other as to the materials that constitute their investigative materials.
So where do you think that leaves us?
Well, Your Honor, I'm sorry. I'm sorry to interject.
No, that's fine, Mr. Stowe. Go ahead.
That seems to be, Attorney Martinez and I actually discuss things and we get along, which is good in this business.
Well, you get a gold star if you get along. That's great.
We do. And I disclose everything I have to him that I can. To back up, Judge, in the underlying case, which is obviously something that's driving the discovery in this matter, there was a subpoena that was done months ago to get the state police records. State police objected to it, pushed back, filed a motion to quash. On August 26th of 24, Judge Coltier drafted a decision ordering them to produce certain records. After that, the order was issued. Matthew Farwell got arrested, and then in the federal case, they issued the protective order in that. And that, I believe, I forwarded to Your Honor. That protects all the information. After that federal order was filed, the Attorney General's office filed in the underlying case. Not that there's an underlying case, but in the civil case, a motion to reconsider Judge Coltier's order of August 27, and that was filed on October 7. We had a hearing, and on October 30th, Judge Coltier denied the order of the request of the Attorney General's office to reconsider her August 27 order, but put in a provision in her newest memorandum decision where the parties themselves could not view the documents, but only the attorneys, and they could view them in the presence of their attorneys. Since that order came down on October 30th, actually on the same day, we received a disclosure from the town of Stoughton that the town of Stoughton had obtained records as part of the internal investigations report, but were hesitant to disclose them because of the Mass State Police's motion in response to the Keeper of Records subpoena. And there are at least 18 Mass State Police interview reports that have been withheld as part of the internal investigations report, which I believe we're here for. I shared that information with Attorney Martinez. So I haven't gotten anything in response yet to the Judge Coltier's most recent order in memorandum from October 30th. I've reached out to Amy Bratskier and one of the other attorneys, the attorney Robert Keeley, who's actually filed a motion. His party filed a motion before he was involved, and they haven't come back to me that they've received any records. So as we sit here today, there appear to be at least 18 interviews that are part of the case we're here for, with Your Honor, that haven't been disclosed to anybody by the town of Stoughton. And Amy Bratskier also indicated that she's going.
But as far as you're concerned, there's now the Judge Coltier has confirmed, other than narrowing the scope of people that could look at the material, she has confirmed her order that you would think would require the production of those state police interviews subject to the protective order.
Correct.
Okay, and that just hasn't happened as far as any participant is concerned.
No, and the town was going to file a 9A motion for clarification as to whether the records it's actually holding are encompassed in Judge Coltier's order, because she reviewed the records in camera. So the town still says we have these interviews, but we don't know if they're part of the order, because we're not privy to the documents that were viewed in camera and marked by the Attorney General's office in whatever sequence of orders. I can send your honor copies of the memorandums of decision if you'd like to review those.
Yes, that'd be helpful. And I know you said you thought I was looking today among my papers to see if I had the copy of the Federal Protective Order. And I'm not saying you didn't send it, but for some reason I don't have that in front of me.
Okay.
And if Lizzie, could somebody check to see if that came in? And if it did, send me a copy. And if not, could somebody notify Mr. Stowe so I could get a copy?
Yep, we'll check right now.
Should I send them to the email for reviews or for standards?
You can send it to Post Review and include Attorney Martinez in the communication.
Yes,
I
absolutely.
think that should suffice.
So we got two things going at the same time here. Let's just stick with I'll come back to the issue regarding the state police material. Isn't the safe thing to do to proceed as if the federal order applied?
Yes.
In other words, why couldn't we proceed just being careful and ensuring that if somewhere along the line the U.S. Attorney's Office attempts to intervene in our proceedings, saying they're concerned about the protective order, first of all, it wouldn't be very well received given their inclination not to respond to the division's contacts. But aside from that, I just think if we're operating as if it were in effect, we could move forward on this matter without concern. Does that make sense to counsel?
It does. As I said, I just need to get the discovery. I need to find out what's out there that wasn't disclosed by Stoughton.
I know, but we got sidetracked a little bit with concern over this federal protective order, and I just think that we shouldn't let that hold us up, because I'm not sure I have the power to. I know when I was sitting as a Superior Court judge, I ran into the same difficulty from time to time trying to get access to federal investigative materials for state case. It's always been a challenge, and I'm sure anyone who's been doing this knows that this isn't all that unusual, unfortunately. Secondly, but again, I think that we'd all be safe. All the participants would be safe if we just operated as if that order were in effect. So I want to see the order. So that means really I need all of you to take a look at the order again, just to make sure there isn't something in there that's unusual and you think that's going to impede the ability of the parties in this matter to proceed.
Yes.
Okay.
Those two orders, by the way, Judge, are the memorandums of decision on the underlying civil case are actually public record already. They're on the website.
The orders themselves, you mean?
Yes.
Okay.
One is
All right.
dated. One is filed August 27. The other one is October 30th.
Okay. Well, but so I'm being lazy. If you can send them to me.
Oh, absolutely, absolutely, absolutely.
Otherwise I'd have to figure out how to do a grown-up thing, like find them on the public access. So if you can do that and make sure that, and Lizzie will let you know if we need another copy of the federal order, just so I can be looking at it at the same time. At least we can put that issue aside and concentrate on this new state police interview material, which I understand your need for, and you should. I can't imagine that if it's been ordered, unless somebody is making some kind of argument, because I'm unfamiliar with the pleadings and the order themselves, that for some reason those interviews are not covered by by the judge's discovery order. And you and you said the town of Stoughton is looking for clarification.
Yes, they let We plan to seek an in-camera review of the above listed records so the court can advise us as to what we can disclose. Stoughton obtained the above records as part of its AI investigation, but was hesitant to disclose them given the Mass State Police practice in response to keeper of record subpoenas. I will, of course, include all counsel on the motion for in-camera review via 9A, which I haven't received yet. That was from October 30 from the attorney for the town of Stoughton.
So this civil case has been grinding along very slowly.
I think what has happened is it has, because of the production in the terabyte of information, that the terabyte of information was put on the disk, but nobody could open it, and it had to be redone.
Right.
So a lot of lag in that. And then, of course, the federal case came up, and that's put a different bite in. I think Your Honor was correct in stating, I believe, was that the discovery in the federal case will give traction probably to the civil case, so we can get discovery better and quicker in the civil case, because, of course, criminal case will take precedent over that. So
Right.
I think that's what's happening. So it'll go. I suspect it will go faster now, unless the Attorney General's office now appeals the judge's decision of October 30th.
All right. Well, that I guess remains to be seen. So we need to see what happens with regard to that discovery. Let's assume that it's just parties acting slowly. I don't want to be critical about whatever the circumstances are. Let's assume for the moment, for our purposes, that it's confirmed that these documents that you're now seeking are indeed covered by the discovery order in the civil case, and that they get produced, and that you get them, and that you have, and we've made a decision about how we'll operate for now, as if the federal protective order is in effect, as it relates to us. Is there any other impediment to moving forward in this proceeding?
No, I just see it as discovery. Being able to get this information, I owe it to my client to find out that the information. Now we know it's there. We now know both sides of us. We now know that town of Stoughton hasn't been forthcoming with all the documents as part of their investigation.
Yeah,
it's something Post should be concerned about too. That my client gets a fair hearing and is entitled to get all the documents that are available from the town.
no. Well, of course, and that's why we've been proceeding very carefully,
Yes,
and appreciate that how attentive you've been in your efforts. So, but my hypothetical is that you'd be in quotes up to date on the discovery that's presently out there and available, assuming the order is in place and you get that most recent discovery. I guess what I'm asking, is there any other discovery or non-discovery issue, if you get that material, you think would require further delay in our proceeding?
I do not. I think the other materials we discussed in private may be an issue that Attorney Martinez is requesting clarification on. But that's it.
Okay. All right. So what I'd like to do is we don't need to have. No, I guess we better do it by hearing. I was going to say, if you could just simply give us notification by a certain date of what's transpired on the civil case discovery issue, that would be fine. But I think we really need not only to get an update, but to meet so we can schedule further proceedings in the normal course of these matters. So what do you suggest as a date for us?
Well, I'm sorry.
Go ahead.
I would expect that we're either going to get the materials within 30 days of October 30th, or the Attorney General's office will have, of course, that's the appeal period will run. So I would expect, for realistic timeframes, that something within the next 3 weeks to find out if I got the materials. And then I don't know what materials I have. But at least I'll have the materials and I can go through them with my client.
Right.
So
So what I would expect it, let's assume again that if you get them, great. If you don't get them, and we'll set a date. But if you don't get them, you should provide us with written notice that, for instance, that an appeal is proceeding, and we
certainly,
can expect a further delay.
certainly.
So let's pick a date. And Ms. Martinez, does that seem all sensible to you?
Yes, it does, Your Honor.
Right.
I think that makes sense. And I think it would make sense to have a conference certainly before the year is out, just to
Oh, for sure.
get an update on the status of everything.
Yeah, absolutely. So let's see, we are.
The week of December 16th, perhaps?
Just looking. Actually, I think I'm going to be literally out of the country that week. So either the week before, or maybe how about Christmas Day? Does that work for everybody?
My wife objects.
Yeah, I get it. I'd be in trouble myself. So I would like to get this done before the end of the year to get us on track. So let's just take a shot at the sort of late the week before that, maybe the 12th or 13th. Does that work for folks?
Judge Fishman, we do have a hearing in another case on December 11th. So earlier in the week might work better, perhaps the 9th or 10th.
That's fine with me if it works for counsel.
It does.
The 9th works for me, the 10th, I have two things scheduled. The 11th, I'm out of state, 12th, I'm out of state.
Okay.
I'm free
So
on the month,
9th?
the other Friday.
All right, let's schedule it for the 9th. We'll do it at the same time. Mr. Stowe, if you learn that there's something's happened that is sort of interfering with our plan here, you'll let us know, and both whether there's been any change in the discovery order, whether discovery has actually occurred, or whether an appeal has been taken.
I will do that.
Okay. And I'm going to assume if I don't hear you about the federal protective order after you've taken another look at it, that you're all game for proceeding as if we're operating under that order as well. Okay.
Yes, and I think it would make sense to get the final discovery that we had discussed at the last conference out, that we can do a like a supplement to the already existing protective order to incorporate the federal order. And I think realistically we should be able to do that by the end of next week.
Oh, okay. Why don't you do that? That's a good idea.
That makes sense.
I'll look forward to seeing that as well. All right. Is there anything else we can accomplish today?
I don't believe so, Judge.
Okay. All right. Well, thank you all, and we'll see you on the 9th.
And
Thank you.
Your Honor, I will forward to the review email the two orders, actually the three orders. I'll send over the federal order and the two orders from the underlying case.
Good.
For your review.
You know what, just to keep us up to date, do you have the request for clarification as well? From Stowe?
It should be online.
From Stoughton, excuse
Yes,
me.
I'm sure I can get that.
All right. Just that I feel more comfortable if I've got a complete file, so I know exactly what, I'm in the same information that you have.
Okay.
Okay. All right. Well, thank you all.
Thank you.
Thank you.